in the matter of Vincenzi v. Reeves, D21-633-8810 and T21-217122N in Clark County, Nevada. My name is Judge Heidi Almase. I'm presiding in Clark County. Do we have our Texas court?
I'm the judge of the 318th District Court for Midland County, Texas.
Hello, Judge.
Cause number here is FM 69805, in the interest of children.
All right. Good afternoon, Judge.
Good afternoon, too.
Can I get appearances from Nevada Council, please?
I represent the natural father of the children, Kevin D. Vincenzi, who is present via Blue Jeans.
Attorney Christine Barnhart, I represent the children's mother, Jennifer Reeves, who is also present via Blue Jeans.
All right. And then we have Mr. Moore.
Texas Council for Jennifer Reeves.
All right. And then on my end, I have a Firefly note taker. Kevin, is that you, Mr. DiVincenzi?
He's muted, but it's something that he has installed on his computer for his meetings, which takes notes for him. But that is him, yes.
All right. So, folks, we are here, I think, first and foremost to do the UCCJEA with Texas, and then depending on what happens there, I know it's 4 o'clock in Texas, so I have reviewed all the underlying pleadings here. I made some notes. I don't know what the Texas court's preference is. Judge?
Judge, I can say I've done the same thing as you, is that I've looked at the pleadings in this file, and Mr. Moore can correct me if I misspeak anything. This suit is what we call a SAPSR, namely a suit affecting parent-child relationship. It was filed by the mother on September 22 of 2021, and in it she has included an affidavit that lists where the children have lived for the time preceding the suit. And in it is that the children have resided in Midland County with the mother since August 13 of 2021. Prior to that, they resided in Las Vegas, Clark County, for a period of 2 months. That is my memory. Looking here for it. Yeah, from July 2021 to August 2021, they resided in Clark County at the address of the father. Prior to that, they had resided in Malibu, California. The oldest child from March 2019 to July 2021. So that's what I know.
All right. I have a similar timeline, Judge. I went through the various UCCJEA provisions that we have. It appears that the Nevada D case was filed first in time on the custody matters. We also have a TPO, temporary protective order, that was filed September 2nd in Nevada by Dad. It doesn't appear that either Nevada or Texas has home state jurisdiction, but I wondered perhaps if, in your estimation, the simultaneous provisions applied.
I'm not really sure what you mean by simultaneous proceedings.
In Nevada, under our UCCJEA, we have a simultaneous jurisdiction statute, which states that if another state has commenced a custody proceeding, let me read it. There's no jurisdiction in Nevada if there's been commencement of a proceeding in another state. Under that provision in Nevada, Nevada would be first in time, but I didn't know if you had a similar provision.
No, we don't. We have just under the Uniform Act, that either one of us could act on a temporary basis, in the event of an emergency. But I'm not sure that's where we are in this case.
Correct.
And your case was filed when, Judge?
We have two in Nevada. We have a temporary protective order application, which was filed by Mr. Vincenzi on September 2nd, 2021. Followed on September 13, 2021, was his petition to terminate the domestic partnership.
And what does that mean? Is that the divorce proceeding?
It would be a custody proceeding here in Nevada.
Okay, all right, okay. So there's any allegation that the parties were ever married, because there's not in my case.
No, sir.
Okay, very good. So my concern would be, and Mr. Moore, maybe I'll make my comment and then let me hear from you, is that my concern is that I don't know of any contact that the father has with Texas other than the application of the Uniform Act. It seems like the last contact that any state had with both parties would be the state of Nevada.
So to my knowledge, the father does not have contacts with the state of Texas. I think one of the challenges, though, is that it seems clear that the parties have not, or that the children have not resided in Nevada long enough for them to establish home state jurisdiction, as the Nevada judge has stated. But there has been such minimal contact that it seems that through the Texas Family Code, Texas would be able to take jurisdiction over this matter. And because the mother and the children are in Texas, and because of the manner in which this case has proceeded, it's our belief that it would be appropriate for Texas to take jurisdiction in this case. In fact, there's some question as to whether Nevada even has a superior claim to jurisdiction over California, given the very limited time in which the children resided in Nevada. And among the three states that are involved here, the children have lived in Nevada the least in terms of time.
Well, not at the time of filing. Maybe today that's true, yeah, but at the time of filing, Texas would have the least amount of time. Right?
Let's see. The filing in Texas, well, I'm sorry, are we talking about the filing in Texas or the filing in Nevada?
And filing in Texas was on September 22nd.
Yes, and at that point, the children had been living in, at that point, the children had been living in Texas since August.
Yeah.
But they had moved.
August 13th, so about 30 days.
Yes, but they had moved to Nevada in July. Now, there was dispute over that issue from the parties, but the mother's timeline indicates that is the time that they had moved there. And in the listings of evidence or submissions and exhibits, we have, both councils have submitted a record from U-Haul showing where the mother had moved, or where the mother paid to have her moving equipment to take her property from California to Nevada. I think as Nevada Counsel for the Mother has stated in her document, the father is all over the place in terms of where he has lived, or where the children have lived. I think the UCCJEA declaration that the father submitted was noteworthy in the sense that it had laid out a different timeline from what he had said in some of his other documents. I believe, according to his UCCJEA affidavit, the party stopped living in Nevada. I'm sorry, the children stopped living in Nevada in June of 2021.
Who says that?
I'm looking at the father's UCCJEA submission. And according to his own submission, the mother and father were in Las Vegas from April of 2021 until June of 2021. And he says that that the mother was in Texas from June of 2021 to present.
We all clearly know that that's not the case. There's no dispute that Mom went to Texas on August 13th. I don't know what document he's referring to, but those facts are not in dispute. So I don't know the point of that argument. We all know she went there on August 13th, and not with the intention to make Texas her home on that date. That intention came about at some later time when it became clear that Mr. Vincenzi and Ms. Reeves were no longer going to have a romantic relationship. But I think maybe, Your Honor, the Texas judge is not understanding that even if Texas were to take jurisdiction of the children, which it appears he's not necessarily going to do, we still would not then dismiss our action because these parties have a domestic partnership, which I don't know if Texas also has domestic partnerships, but right, so we still will have a surviving action here, Your Honor. The parties are in something akin to a marriage that has rights of property and debt and other rights and responsibilities to each other. So even if you were to take jurisdiction of the children, we would then have simultaneous proceedings in Texas regarding the children and regarding Mr. Vincenzi and Ms. Reeves in Nevada. I think that judicial economy alone would say that that is not the prudent course to take because they would have court appearances in two different states. And I don't know.
I'm sorry, I interrupted. Finish, please.
I am. I wasn't sure that you understood that that's what I think our judge was talking about, not only with First in Time, but also that we still have a surviving case here regarding Mr. Vincenzi and Ms. Reeves, no matter where the children's jurisdiction lies.
Yeah, again, if you're saying that there's actually two, what I understand to be, there's two causes of action there. One would be the domestic partnership, which would be akin to a divorce in Texas, including children, and then the other one is a request for an issuance of a protective order.
Correct. There's already a protective order that was issued here in September, Kevin versus Ms. Reeves. That is a separate case. It has a T designation. And then we have a D case, which is the dissolution of the domestic partnership with children.
Yeah. But the protective order is not a final order. It's just an ex parte, correct?
That's correct. Our court did extend it, but it is now, so it's an order. Judge Almase did extend it, but it is subject to her jurisdiction, yes.
Right, but that's a matter that still needs to be concluded.
Correct.
Correct. There would need to be some discussion and some final order on that as well.
Well, given the totality of the circumstances, Texas declines jurisdiction.
And Nevada will accept jurisdiction?
Thank you.
Judge, do you need any kind of order or minutes in order to close your Texas case, or do you need anything from me?
Why don't I do this? Why don't I just prepare an order that following this hearing, Texas, it is ordered that Texas has declined jurisdiction, and then I will sign that, and then I will email that to you so that you can file that in your cases out there, and that should be sufficient. That's what I've done in the past.
All right. Very well. Thank you, Judge. It's a pleasure.
Judge, could you give me an email address? Or let's do this. You might want everybody in the world to know your email address, so would you mind calling me at 432-688-4391, and that's my private number, and then you and I can talk privately about exchanging email addresses.
423-688-4391.
Yes, 432-688-4391. That's my direct number. Well, thank you all. I appreciate it.
Thank you, sir.
Thank you for your time, Your Honor.
Thank you.
All right. So, all right. Mr. Moore, do you want to hang out and observe?
Sure.
Okay.
Thank you.
Welcome to the great state of Nevada, sir.
Happy to be there virtually.
All right. Okay, folks. So we have a couple issues pending. We have the TPO issue, and then we have the underlying stuff. So, Ms. Gallagher, we have your objection on file in the T case. I had a notice of non-opposition filed at 12:35, and then a 301 objection, or opposition rather. Do you want to start with that, or would you prefer to start with the D case as plaintiff?
Given that they're in separate states and and we have communication, I don't know what your intention is long-term about the protective order. In a lot of these cases, we institute a behavior order. I might be okay with that depending on where we go with my requests regarding temporary custody orders, temporary support orders. I'm sure you probably have gleaned Mr. Vincenzi has not seen the children since Ms. Reeves has been in the great state of Texas since August 13th. There have been multiple discussions between Ms. Bernhardt and I about Mr. Vincenzi seeing the children. They all involved Mr. Vincenzi traveling to Midland, Texas to see his children, staying in a hotel room, and we have not been successful in getting him what I believe is his rightfully owed custodial time with his children. I've been trying to do this since the beginning of September. Mr. Vincenzi has a home. He's a long-standing resident of the state of Nevada. He's been here for years. It's the home that he shared with Ms. Reeves. He has a nanny. He has means to travel to pick up the children or to accept the children from Ms. Reeves and bring them back to Midland. We need a temporary custody order, and there is no reason for him not to have quality time with his children. They're young, and they need to bond with their dad.
All right. So
That's my biggest concern today.
All right, and I'm scrolling through because what I have on for today, Ms. Gallagher, is the UCCJEA and then the TPO objection case, and I see that we also have a motion scheduled for December 4th.
Well, Your Honor, I had asked for, I think you had put on my request for an order shortening time on my motion, but then it was determined that we needed the UCCJEA. So I believe at the last hearing, I was granted an order shortening time on my motion for a pickup order, for contact with the children. So, I mean, I think that we all are at least prepared on a temporary basis to get him some contact with the children and have him not wait until December 4th.
Well, the motion for preliminary orders wasn't filed until November 8th. It was after our October 14th hearing.
I've scheduled I've filed 3 or 4 motions for him to have contact with his children.
We have a lot of pleading in this case. Yes, ma'am.
Yeah, Your Honor, look, as far as the TPO is concerned, like I said, they are communicating. My client's getting FaceTime with the children. We need a behavior order that keeps the parties away from each other. We can't have a permanent temporary protective order, obviously. By its very nature, it's temporary. We do need a behavior order. And then with that, I mean, I don't think we need to really argue or spend a whole bunch of time on the T case. The temporary protective orders, by their very nature, are temporary. So
to that end, are you stating that it should be dissolved if we have a mutual behavior order?
Only if there is a behavior order put in place, absolutely, which requires that the parties stay a certain distance from each other, only to exchange the children. Could there be any contact? Only if both parties desire that. There will be no calling of colleagues or coworkers or employees. There will be no, I'm assuming you have a standard that we could review.
All right. Ms. Bernhardt, I know you've been patiently waiting.
I agree that we should dissolve the TPO. It's no longer necessary, and an extension has not actually even been requested by Mr. Vincenzi. We're going to have the behavior order that we entered into this matter. I would also like to address Ms. Gallagher's assertion regarding the motions she filed for temporary orders regarding custody. She filed ex parte motions that I was never served with, so I have not been able to respond to any of those motions. The order in time that was granted, I believe it was granted on her motion for court to set UCC-JEA conference for order 7 hearing regarding custody and ex parte request for an order shortening time. However, in that motion, she didn't actually make any arguments regarding custody. It was simply to set the UCC-JEA conference. So if Ms. Gallagher is going to request that we set a hearing to do custody, I will request that she file a proper motion so that I am able to respond to such.
So, just for the record, we had a lot of interim pleadings, and the reason that the extension didn't get triggered in the TPO case was because when we granted the OST on Ms. Gallagher's initial motion, I snatched it into the department. Subsequently, I've learned it's better to wait for the process to weave through TPO or wait for something for the hearing master. But Ms. Gallagher's motion is a regular motion. It's not an ex parte motion. It was filed on November 8, 2021.
That's my motion.
That's your motion. Oh, I apologize.
That's my motion.
I didn't file a motion on November 8th. My motion, she's absolutely correct. I filed an ex parte motion for a pickup order. That was before Ms. Bernhardt was counsel, but she does have a copy of that motion. She's on notice that Kevin has been trying to see the children since August. I don't know that you need to have a formal motion in front of you to order time with Dad. I think you should take briefing, but I don't see anything that would preclude Dad from having time with his children. It's really not okay to wait till December 4th to give him time with his kids. That's not the date on my motion. And she's withholding the children, Your Honor. It's been going on for months.
Okay. So the ex parte motion filed by Ms. Gallagher was filed September 27th,
Correct.
2021. And then the November 8th motion is filed by Ms. Bernhardt on behalf of Mom. All right. So, folks, this case is eligible for CMC. Ms. Bernhardt probably doesn't know. I know Ms. Gallagher knows. I'm happy to make orders to keep the peace pending more formal briefing. That anticipates, of course, that there's not a significant objection. So far, parties seem to appreciate that. I haven't had too many issues with it, but Ms. Bernhardt, are you opposed to something that to dissolve the TPO? There doesn't appear to be any objection to that. A mutual behavior order seems appropriate. I don't have a standardized one, so I would request Ms. Gallagher and Ms. Bernhardt work together to formulate one that works for the parties in this case. I just want to make a record too. I don't find that Judge Foreman's determination to issue the TPO was clearly erroneous, and that's the standard on the situation. I noticed there were different issues raised in the objection opposition, but I'll go ahead and order that dissolved. We'll get a mutual behavioral order.
I'm sorry.
Yes.
Could we not dissolve it until the behavior order is actually entered? Would that be something that we could do? And I would work diligently with Ms. Bernhardt to get a behavior order on file by Monday.
Sure, I can make an order that the temporary protective order in T21217122N There's no dispute. The parties have stipulated that it'll dissolve upon execution and filing of a mutual behavior order. So
Thank you, I
that takes
appreciate
care
that.
of that portion. Ms. Bernhardt, how do you, there is the ex parte request for return of children. Do you have any opposition to some orders that might keep the peace today, or would you prefer to go to briefing?
I prefer to go to briefing so I have time to properly respond to everything that she filed before I came into this matter.
Okay.
I did request when I did enter the matter that she forwarded courtesy copies of anything she had filed, and
Okay.
I was not forwarded those documents. I didn't realize they were there until I logged into Portal to look for something else.
Okay, so what that would anticipate then is that Ms. Gallagher could seek to go forward on her ex parte request now that the jurisdiction issue has been resolved. I'm fine with that. Clearly, we have the appropriate UCCJEA jurisdiction that's been resolved. We have personal and subject matter jurisdiction. That is our most extreme option in family court, is an order for return of children, and lately it's included a bench warrant, or not a bench warrant, a warrant for return of child. If the parties are able to reach any kind of accommodation today, that might be a better alternative.
Yeah, I've tried. I have given my word and offered to sign stipulations that my client would not withhold the children from Ms. Reeves, pending orders of the court. But my client cannot be forced to go to Midland, Texas and stay in hotel rooms to see a 2-year-old and a 1-year-old that are his children. I mean, the parties have joint physical custody until a court orders differently. Mom has stayed in Texas against Dad's wishes, didn't go there and, for a move, went there for a visit, and because they broke up, decided she wasn't coming back, and took the extreme position that Dad now is forced to go to Texas to see his kids. I'm still willing to agree temporarily for there to be a sharing of the children, despite the actions of Mom, pending an outsource evaluation, which I think is definitely necessary in this case, and would be helpful to the court to determine long-term custody. Mom wants to stay in Texas. She's welcome to stay in Texas. We can't tell her where to live. And my client will somehow facilitate the custodial scenario with the children. But Dad he needs time with his kids. And Dad would like to have the children for a few weeks, and then Mom can have the children for a few weeks, and we'll go from there. And hopefully we can get some a custodial evaluation done within the next 60 days and be back in front of you.
Ms. Bernhardt?
I've actually I was going to say, she and I had a few conversations regarding some temporary custodial agreement, and what is correct that Jennifer has requested that Kevin come to go to Texas to exercise time with the children. However, Kevin has also requested that, Jennifer's requested her to get some of her stuff back from Mr. Vincenzi that's in Mr. Vincenzi's possession. Suggested that Jennifer fly from Texas to Las Vegas with the children, that Jennifer meet Kevin's friends at a storage center, and that Jennifer stay in a hotel for an undisclosed period of time. There never actually was a time frame for this. And that Jennifer drive back to Texas in a U-Haul of a 2-year-old and a 10-month-old. So, that seems ideal for one person to be, again, as Kevin doesn't want to stay in a hotel, Jennifer doesn't want to spend a week in a hotel in Las Vegas where she knows nobody. But, to facilitate this. The parties have both requested that the other party travel to where they are, and we've kind of hit a standstill with this, as Jennifer is not allowed on the property. Jennifer has been unable to get her possessions back. We requested that Kevin allow Jennifer to enter the home, that she can get her possessions, and we have stated that Jennifer will be returning, but she wants the assurance that while the children are with Kevin, she can get some of her stuff so that she can take it with her back to Texas. Additionally, she can drive from Las Vegas to Texas in a U-Haul with 2 small children. There's U-Hauls on the back seats. There's no where she can put baby seat. You can't have 2 small children in a front seat next to her in a U-Haul. The ideas that they've been proposing are not really workable.
So So Ms. Bernhardt, let me just inquire, if Ms. Reeves were to come to Las Vegas to obtain her personal items, would she be planning to get a U-Haul and drive back to Texas, or did she want to put them in storage somewhere else in Nevada? What was her plan?
They're in storage already.
Kevin has put some of her possessions into storage. We requested that Kevin give us an inventory of what is in storage, as Jennifer entered into the relationship with a variety of personal items, including furniture. We don't know if that's in storage, we don't know if that's in the house. We have not been provided with an inventory of what Kevin put into storage. Additionally, Kevin has told Jennifer that he would pay for her move from Las Vegas to Texas, and we requested that Kevin facilitate that, so that Jennifer is able to hire movers and have someone drive her possessions back, because she can't make that drive with two small children.
Okay. Ms. Gallagher?
We're not necessarily opposed to that, Your Honor. We were trying to negotiate some time for Kevin. She didn't want it to be very long, so just to try to get him some contact with the kids before this hearing today, we suggested she stay over for a weekend in Vegas while he had some time with the kids, but that's ultimately not what he wants on a permanent basis. She was pushing to get her stuff, and we wanted to try to make it happen. My client did send a small shipment of her items to her in Texas. She said that her computer was broken. He decided he didn't want to take responsibility for shipping or sending her items because he didn't want there to be allegations that he had broken her items. So they are in a storage facility. I provided Ms. Bernhardt with information regarding the storage space and the unit number. She can have access to it. She provided us with a very long list of all of the items that she wanted. Mr. Vincenzi has placed all of those items into the storage unit. So he is willing to help her financially to move her stuff to Texas. We just need to know what she wants.
So Ms. Gallagher, is the storage unit in Mr. Vincenzi's name, or is it only in Ms. Reeves' name?
Kevin, I don't know that answer. Can you tell us? You have to unmute yourself. There you go. No, we can't hear you for some reason. We can't hear you. Hold on. Can you text me whether or not it's in her name or your name? You could text me.
While he's doing that, Ms. Bernhardt, is Ms. Reeve asserting that in addition to retrieving personal items, she would also like the opportunity to conduct some kind of inventory of items that might be in dispute, or?
I believe in the motion I filed on November 8th, we do have a list of the items that Jennifer is requesting. I don't think there's anything beyond that, but Jennifer would be able to speak to that better than I would.
All right. Ms. Gallagher, have you had an opportunity to take a look at that?
Yes, he said it's in his name, but he can switch it over to her name. That's not a problem. He could take his name off of it. But he indicated to me, and tell me if I'm wrong, Kevin, that everything on her list is in storage now, correct? Still can't hear you. And
Yes, this is in storage, and then we added a bunch more stuff that I had in the house, furniture and extra stuff that she has everything on the list and then some.
All right.
for the children, additional items for the children is what I think he's indicating.
Different items, that's correct.
Is
Yes.
that all, that's all in storage or at the house?
Her property is not her property anymore.
I didn't catch that.
Sorry. I'm sorry, what was the question, Your Honor?
The children's items, are those at the house or in storage?
They're in storage. My plan was when I had the children, I was going to buy new items for them. I think the only thing I have left here is one of the cribs because we have 2 cribs.
Understood. Okay. All right. So it seems to me we have contact issues, visitation issues, mutual behavioral order, and Ms. Reeves obtaining, at minimum, the items that are on her list. Is that a fair statement?
Correct.
All
Yes, Your
right.
Honor.
All right. So the problem, ordinarily in these circumstances, based on the motion just having been filed and having had to sort of wade through these other items, I might be inclined to order electronic visitation in the interim until we could get everything fully briefed, but the children are too young for that to probably be any kind of meaningful interaction for Dad. I'm happy to do that today.
He does have that already, Your Honor. We were able to work that out. He sees them FaceTime every day at 5 p.m., but you're right. I mean, especially with the younger child, it's not really meaningful
All right.
contact.
So, folks, at this juncture, Ms. Gallagher is correct. If Ms. Reeves elects to stay in Texas, that's her issue. At this juncture, however, notwithstanding the underlying allegations, we have allegations of domestic violence on both sides. We have a situation where Ms. Reeves is retaining the children in Texas. So, given the age of the children and the fact that they can't travel alone, it would be difficult to travel with two small children in a vehicle. Any kind of interim visitation is necessarily going to involve, in my opinion, flying with the children to Nevada with a parent. I'm assuming that this would be a situation where the parents would want to travel with the children as opposed to designating a third party, not to mention that you have a toddler and a small child. That might anticipate a exchange at the airport for a period of time because these children are not in school. It appears to me that the parties have some financial resources to be able to accomplish this. I don't know if a 2-week on, 2-week off, or month on, month off is reasonable. But I guarantee you that if we have to fully brief this and I make temporary orders, that's kind of where I'm at in terms of what would be appropriate. I have to hear the custodial issues in the division of the estate on the merits. Where I have allegations of domestic violence on both sides, your attorneys are going to tell you the standard is clear and convincing evidence. I have to make a variety of findings if that's established, and it's been alleged on both sides. So it seems to me today at minimum we have the mutual behavioral order, which upon my signing it and filing it will result in the TPO being dissolved. It is also very fair for Ms. Reeves to be able to obtain her personal items from the storage unit in order to avoid conflict. Mr. I'm sorry I'm butchering your name.
Vincenzi.
Yes. I would appreciate if by close of business tomorrow you would have that transferred to Ms. Reeves' name so that she doesn't have to interact with you in order to obtain her items.
Yes, Your Honor.
I'm going to ask that you maintain payment on that storage unit until Ms. Reeves is able to make arrangements. So what I don't want to happen is for you to say, okay, hands off, it's on you. I don't want items to be lost in the midst of the litigation. So we have the mutual behavior order, which is filing is conditioned on dissolving the TPO. Ms. Reeves certainly has leave to obtain her personal items from the storage in Nevada. Mr. Vincenzi will have that transferred over to her name, but will maintain payment until a decision is made on closing the unit or some other agreement. Sir, you'll have that transferred over by tomorrow, which is November 19th, close of business at 5 o'clock. We already have electronic visitation in place. That leaves us with, I anticipate Ms. Gallagher is going to file her opposition and counter motion, which will include the request for outsourced custody evaluation, unless there's some agreement today. Ms. Bernhardt?
Sorry, quick indulgence.
Take your time.
I think that does cover everything, Your Honor.
All right. So there's no.
So, Your Honor, are you saying that you're going to put it off until December 4th? Is that what your ruling is today?
My preference would be to do some sort of interim visitation order today.
That's what we're asking for, without prejudice.
Yes, without prejudice and pending full hearing on Ms. Bernhardt's motion on December 4th.
Can I make a proposal
Yes, ma'am.
that Ms. Reeves fly to Las Vegas with the children? My client will pay for the flights. that he would then return the children to Midland, Texas. He would also pay for those flights. That would give her an opportunity to be able to take a look at the storage unit and do her own inventory of what's in there. And then she can, through her counsel, tell us how she wants to move those items to Texas. My client will make sure that occurs as long as it's reasonable, as long as we're not asking for it to be taken by limousine, something, crazy. But he'll make arrangements to then have that sent, and then we can appear back in front of you after we brief it a little bit more and get an outsource.
So for what period of time are you requesting, Ms. Gallagher? Just until the motion?
Kevin, are you asking like 2 weeks, Kevin, or 2 weeks on, 2 weeks off? I think a month is too long for kids to be away from either parent.
Yeah, I haven't seen these children in 90 days, so 2 to 3 weeks at least for them to settle in would be ideal, for sure.
All right. Ms. Burns, do you have a proposal on your client's behalf?
Well, I believe the younger child is still breastfeeding, and the older child is enrolled in a preschool program. And I have someone kind of into a routine in Texas, and not want to disrupt that routine too much, especially with the breastfeeding. I'm not sure how long the baby can be away from mom. I'm about to discuss that more in depth with Jennifer, but I think 2 or 3 weeks seems like a long time for children that young to be away from mom, especially when they're still breastfeeding.
Ms. Gallagher?
Your Honor, the child is a few weeks away, 5, 6 weeks away from being 1 year old. I think that he's received the benefits of breastfeeding, and to argue that breastfeeding is more important than to have time with his dad is more of the same. He's on solid food, and the older one attends a church camp this week, an informal preschool, and it was not with my client's consent. I just find at this point these arguments to be very disingenuous and not in the best interest of the children. They need a relationship with their dad. And they also have a sibling. My client has a daughter named Gianna that spends significant amounts of time with him. As a matter of fact, my client's going to have her over the next week for Thanksgiving. He's flying down to California to pick her up tomorrow. And they have a close relationship with Gianna, and they haven't seen Gianna in 3 months. So that's another factor that the court should weigh.
So Ms. Bernhardt, on behalf of your client, what I heard that was that, not that there was necessarily opposition, but that 2 weeks was too long. Did I intuit correctly?
Jennifer's never fully opposed the children, well, she's never opposed the children with Kevin. It's been more working out logistics so that Jennifer wasn't forced to be around the travel with the children by herself, driving a U-Haul with the children by herself, and spend, I think the last proposal was a week or something, where Jennifer would be in a hotel room by herself in Las Vegas, which just, she doesn't have family here, she doesn't have friends here, she lived here for less than a month.
All right. So
No,
here's what I'm going to do temporarily, without prejudice, to keep the peace under the rule. I'm going to use this as a case management conference because an answer has been filed, and I want to keep your case moving. You guys have already had a lot of court hearings, and it gets very expensive very quick. This is just going to be a temporary situation until we get to that fully briefed motions setting, taking into account that Nevada has jurisdiction. At this point, Ms. Reeves has been in Texas for a period of time. There's a dispute as to how the Texas travel occurred, why it occurred, and for what portion of time it was meant to be. These are all issues that will have to be resolved. I just do want to put the folks on notice, although the circumstances that bring us here today are a tad unusual, because Ms. Reeves is in Texas, there's at least a notice component to relocation. So if that is going to be ultimately pled as we head towards a permanent resolution, I do need to let the parties know that the time spent in Texas, there's a case, I think it's Druckman v. Russetti, which says that we can't use the time period that's spent in Texas as a basis to show the factors under the relocation. I'm sure the attorneys will fully advise their clients. It's a very particular area of law, and I'll wait and see what's pled, obviously, but that comes to mind at the outset. Given the age of the children and the amount of time that Dad has not had time with them, and the cost of travel associated, I think the 2-week on is doable at this juncture. If we retained it, likely that might get cost prohibitive, but for the interim, to the extent that Mr. Vincenzi has offered to pay for Ms. Reeves' travel and the children's tickets to Las Vegas, and that he has additionally offered to pay for the tickets to return the children to Midland, Texas, to include his ticket and the children's, I will accept that proffer. I'll make that a temporary order. Quentin, what's the number of weeks between now and December 4th?
No, I'm sorry, the hearing is actually December 14th, not December 4th. I just don't want the math to be
All right.
wrong.
Thank you. I appreciate that. Today is December 14th.
It's about 4 weeks then, so it should work.
4 weeks. All right. So, Ms. Gallagher, what date were you anticipating?
So Kevin, with your travel schedule with Gianna, what would work best for you to be able, you'd have to get Jennifer a round trip ticket to bring the kids, obviously, and then tickets when you return them.
Right, so again, there's 2 flights total going and coming from Midland per day. They originate in Midland, Texas at 8:30 a.m., if I'm not mistaken, and then a flight leaves Vegas at 12 p.m. Vegas time. So it would only make sense that Jennifer, if she can, would bring the kids on that 8:30 a.m. flight, whatever date we pick, and then I would return the kids, 2 weeks later, whenever the time we decided, on that 12:30 flight. So the challenge is if I had to go pick the kids up, then I would literally lose a day and a half with Gianna because I would have to stay in a hotel to get that next flight out the next day. There's only 1 flight in, 1 flight out direct on Southwest.
It wouldn't be a problem for Ms. Reeves to come to Las Vegas. It's returning.
And she would, right, she can do the initiating flight and get back the same day with no problem. It actually works in her favor because the flights originate from there. For me, it's the opposite, which I wanted to do on the return, spend the night in Midland and then return back because then I'm on my own. That's not a big deal. I don't mind doing that whatsoever.
Monday, right, for her to fly in, so the tickets.
That would be great, absolutely.
So Monday is November 22nd. So, Mr. Vincenzi, if I understood you correctly, I know I butchered it, I apologize. My understanding is that you would fly for Ms. Reeves to come out with the children. Are you also offering to pay for her return ticket to Midland?
That is correct, right?
All right.
Yes, correct.
I want to make sure I understood.
Absolutely.
All right, so that's November 22nd. 2 weeks is, the 29th is 1 week, and December 6th, Monday, December 6th is 2 weeks.
Then you would fly down on the 6th then, Kevin, unless there's a problem with that, to return the children.
Not a problem.
All right, and what that anticipates, if I understand you, sir, correctly, is that you would not be able to return to Las Vegas until Tuesday, December 7th. Is that correct?
Correct.
Okay. So that would take us 1 week to the December 14th hearing. And then that would anticipate, hopefully, that we would be able to have temporary orders in place following full briefing. Otherwise, if not, if there were any delay or any issues which precluded hearing, I never know what might happen. But Mr. Vincenzi's next visitation, if there are no temporary orders, would commence on December 20th. I understand they're the holidays. I'm hoping that we don't have any issues and that we have the hearing on the 14th, and I have full briefing, and we can go through and do everything that we need to do. Just in an abundance of caution, because we're in plague time, and it's the holidays, and things come up, and I just want to put that on the record.
And I just wanted to request, I discussed this with as we get the time. If Jennifer is going to be flying to Las Vegas, I would recommend that we get her stuff out of storage and move her stuff while she's here.
Absolutely.
So I'll
figuring out a return flight for her after she can go to the storage unit. If she wants to spend the night and fly out the next day at 12:30 so she can go to the storage unit and take a look, that's okay too. I mean, just Ms. Bernhardt can tell Mr. Vincenzi and I what the ticket should look like. We're fine with that.
There's also, is the storage unit like a keypad lock or is it a key lock?
It is a keypad lock.
Okay, so you're just going to try to coordinate exchange the key, but you don't need to do that.
Well,
Yes.
and here's the issue, folks. The reason I asked that it be transferred to Ms. Reeves' name and that Mr. Vincenzi, sir, I'm just gonna. That Dad would maintain the,
You're freezing up on us, Your Honor. I'm losing you.
do you still have me, Miss Gallagher? Ms. Gallagher is frozen. Yeah, it is. It's. Folks, hang on. We just, there she is.
I missed a whole bunch of that. I froze for some reason, but I'm back.
So my goal in having the storage unit transferred to Ms. Reeves is that Dad will maintain payment on the storage so that there's not a rush. She'll have some time.
Correct.
It
Yes.
doesn't have to occur in 24 hours, but I am going to ask Ms. Reeves to communicate through her counsel when it's resolved so that it's not just left there. Whatever arrangements she makes related to the storage unit should be communicated through counsel.
I'm fine with that.
All right, so we'll do that, the visitation, Monday, November 22nd. Dad is gonna pay for Mom and the children's tickets to Las Vegas as well as Ms. Reeves' return ticket to Midland. He'll have, temporary visitation pending briefing from November 22nd to December 6th. He's agreed to fly to Midland to return the children to Ms. Reeves. The exchanges of the children should occur at the airport in a public area, probably outside the gates, just to avoid any issues between the parents. Do we need perhaps a communication application to assist the parties?
Jennifer did bring it to my attention. I think it was our fellow wizard that Jennifer had looked into. I'm not sure if it was our fellow wizard or Talking Parents. Jennifer, which one was it that?
I'm trying to always share my phone because I froze again on my computer, just to let you know.
So Ms. Gallagher, my request was that perhaps a communication app might be of assistance while we navigate to hearing.
Well, they've been using email for all of their communication because that's what the TPO said. I don't know that it matters. I mean, all of their communication is in writing. And then, so it doesn't matter to me. They can use our phone wizard if they want to, but they've been using email.
Ms. Bernhardt, do you want to stick with email for now?
I think one of the apps might actually be a little bit better because I feel like this is potentially going to be contentious and I would like the documents if we need them.
All right, so it's going to be our family wizard, folks. I need you to get signed up. There's no cost unless you're exchanging documents. I need you to do that by close of business tomorrow, which is November 19th. I keep losing people.
Yeah.
There we go. Okay. So I think that's sufficient to carry us through to hearing on December 14th. Ms. Bernhardt, anything for you or your client?
No, I think that covers everything. Thank you, Your Honor.
All right. Ms. Gallagher, anything for you or your client?
I'm asking you right now, Kevin, is there anything else that you need addressed? I mean, I think I've answered all your questions, but...
No, I think we're good. I'll probably bring somebody for the transition as well, just so I have a witness, because it is pretentious, so, but beside that, no, I'm good. Thank you. Thank you, Your Honor.
All right. So just remember, sir, what's good for the goose is good for the gander. So,
I request that Kevin does want to be a third party to the exchanges, that's fine, but we are going to request that that third party is not the nanny. As there have been some issues between Jennifer and the nanny
all right.
previously, and that relationship doesn't seem all that.
There are some funds that we proposed, like for an exchange at the storage. We'll just...
So if we transfer the storage unit, I don't anticipate we'd need anybody to be there. That was my hope in making that
Right.
an order.
Right.
Folks, why don't we do this just in an abundance of caution? No third parties. Please exchange the children in a public area at the respective airports. Because you have a baby, you're going to have to exchange the baby. It's not going to make sense for you guys to be holding cell phones when you have small children to exchange. But my hope would be that if you're in a public area, you would be able to manage 2 exchanges. Ms. Reeves, yes?
My client is saying that it's not safe because she attacked him with the baby in his arms, and that's what led to the filing of the TPO.
All right.
So,
So what do you suggest, Ms. Gallagher?
I think we were suggesting that, I was suggesting a third party, but I don't know who Kevin is suggesting, or you can suggest
Your Honor, I can be close by. I've got family, friends, and employees of mine for 15 years plus that know the children, speak to the children, their family, but I can be very close by. I'm just trying to avoid any interaction or any allegations or anything else. It's
Okay.
just.
So let me make sure I understand you, sir. You want to bring somebody with you, and you want to stand to the side and have Ms. Reeves or her designee exchange the children, and the 2 of you go to your separate corners and leave. Correct?
That would be ideal. And I would do the same thing on the return. I would take somebody with me so that they could do the actual exchange. I think it would be better on the kids anyway, so they're not being torn right away from mom or dad.
Okay. So do you have someone in mind, sir?
I could use Anthony Almase. He's been my employee for 15 years. The kids know him well. They know his mom well, so I could definitely use him.
Ms. Reeves,
Well,
do you have
yep.
any objection to Anthony Alves? Ms. Reeves? Okay. Is there someone that you would like to bring as a designee with you? Okay, so you would...
Jennifer, is your sister going to accompany to the North Texas Airport for the exchange? When Kevin flies back with the children on December 6th?
I don't know.
All right.
Yeah, if that can happen, then I do have to bring somebody with me, Ms. Bernhardt. So.
I think that would be the December 6th exchange. So if we do Anthony at the Las Vegas airport and Jennifer's sister at the Midland airport, does that work for everybody?
All right.
Well, works for me.
So let's do that. Ms. Reeves' sister in Midland, Mr. Alves in Las Vegas. Again, folks, these are just temporary. No prejudice is applied to any of today's orders. It's just to keep the peace until we can come back on December 14th and hear everything on the merits, okay? This is just interim to carry us through,
Thank
okay?
you. This is good for everyone to get clarity. Thank you so much.
Yes, okay, so Ms. Gallagher, I would anticipate you'll work with Ms. Bernhardt on that mutual behavioral order. The TPO is going to stay open until it's signed and filed. I burned through that order app as quick as I can. Yes, Ms. Bernhardt?
So if Jennifer does fly on the 22nd, if we haven't gotten the behavioral order signed and filed by that day, can we stipulate now that Jennifer is permitted to go to the house, she's not doing the house, right? Everything's in storage?
Storage. Usually I get stuff in very fast from both of you.
I will do my best to get something to you by Monday. I think I'm just going to take one of the other department's standard behavior orders. So there shouldn't be any disagreement from Ms. Bernhardt if we use another department's behavior orders. So.
Most of the standard ones, yeah. So just, I have to rush down to family court for a job interview this afternoon, but if you get that to me today, I'll look over it either tonight or tomorrow morning.
Thank you.
Perfect. All right, guys. Have a good holiday. I hope all goes well for you, and I will see the attorneys sooner rather than later.
Thank you, Anna. I appreciate your time today. Thank you so much. Bye-bye.
Bye.